You start getting professional prosecutors developing in the 1730s in England, in America in the early 19th century. Up until then, victims prosecuted their own cases. Defendants mostly defended themselves, but once you had professional prosecutors, you then developed people bringing in defense lawyers, still in a minority of cases, but over the course of the 19th century, more and more people. It's only once you have lawyers as prosecutors and defense lawyers that you can get developing these rules of evidence, rules of procedure. You finally have law schools in America, so you have judges who are trained as lawyers. And so the rules of evidence and procedure get more complicated. Trials at the time of the founding in England took maybe 20 minutes in London at the Old Bailey. So you could do dozens of them in a day. In America, maybe they took a couple of hours. It was the victim and defendant telling their own stories. But as they grew longer with rules of evidence and jury instructions and the like, they became more cumbersome, and prosecutors and defense lawyers started this thing called plea bargaining, where they would say, okay, I charged you with 4 things. We'll drop 3 of the charges if you plead guilty to the 4th one. And so gradually, as the trials take longer and are more cumbersome, the lawyers find ways to short circuit the juries and to speed the cases along. Well, that may be good for their own interests in getting cases over with, but it then deprives the public of the ability to see justice done, and people start to worry, well, what are these deals that are being cut? And so, especially over the last 100 and 150 years, we moved from just a fraction of cases being plea bargained to today, maybe 95%, 19 out of every 20 cases are resolved by plea bargain without a jury. And so jurors actually are involved in only a small sliver of criminal cases, very different from the system that the founders envisioned and tried to set up. It certainly is true that we're able to prosecute many more cases than before. You know, there are now professional police forces. They developed in the 1830s, and they catch many more. There's much more crime. It's more violent, and prosecutors can move these cases along. At the same time, it short circuits the jury. It means that there's more jumping to conclusions, more focusing on an initial suspect, and less testing of something at trial. Now, if someone persists to trial, the trials are longer, they're more elaborate, they're more evidence rules. But then there's this enormous pressure to surrender the constitutional right to a jury trial, because if you go to trial, you're probably going to get a significantly longer sentence. And most of the people who plead guilty wind up with a shorter sentence than that. The heavier punishment goes not to the criminals who are the worst ones, but to the ones who dare to insist on their right to a jury trial. And again, that is not the system the framers envisioned, where the juries would have made sure the worst punishments go to the worst people and not penalize people for exercising their rights. A jury trial in a simple case can take a few days, but often take a week, 2 weeks, and you have very complicated ones that can run for months, where there will be one or several lawyers for the prosecution, there'll be several lawyers for the defense. First of all, they're going to select a jury in a process that might take half a day or several days out of a pool of dozens or 100 people, winnow it down to 12 jurors and maybe a couple of alternates. Then there's going to be some arguments from the prosecutor, from the defense lawyer, a series of statements, but there's a lot of mechanics that goes on outside the jury. The prosecutor and defense lawyer are having private conferences with the judge. The judge is serving as a gatekeeper, keeping the jury from hearing certain evidence, instructing them on what they can and can't consider. And at the end of the case, the judge says, here is the law you're supposed to apply. The judge tells them what law to apply. And then the jury applies it in order to find facts, to find the person guilty or not guilty. But then after that, the judge is usually the one who sets the punishment, except the jury does have some role when it comes to death penalty cases. The legislature typically says, for a burglary, for example, the sentence might be anywhere between 0 and 20 years. And the judge will take the parties' arguments, look at the defendant's prior record, listen to any excuses or mitigating circumstances, and pick a punishment. And the judge has broad discretion within that range. There's not really any jury involvement in it. The jury's involvement is limited to finding facts that raise a maximum sentence or a minimum sentence. In a death penalty case, the jury has to find the facts that make someone eligible for the death penalty, but still the judge can ultimately accept or reject the jury's recommendation after that. And so the jury has to authorize it, has to find the verdict of guilty, but doesn't have the same final say on punishment that the jury would have had at the time of the founding.